an appeal in the matter of Merck Serono SA and the Comptroller-General of Patents, Designs and Trademarks.
Yes, Mr. Mitchison.
May it please your lordships, I appear for the appellants Merck Serono with Dr. Selmy, and my learned friends Drs. Edward Stewart and Barron appear for the controller.
Yes.
As your lordships will have gathered, on this appeal I shall seek to persuade you that the correct interpretation of Article 3D of the SPC regulation, now assimilated into UK law, is that SPCs for second medical use patents should be permitted. And so in this case, an SPC should be granted to extend protection for the use of clobidogrine in a recent approval to treat multiple sclerosis, which the court will be very aware is a serious condition, even though the active ingredient had first been approved many years earlier to treat hairy cell leukemia. In other words, we say that the CJAU was right in Neura and wrong in Santen, which this court is entitled to decide post-Brexit, as if departing from its own case law. And the basis for this...
Before you go on, can I just be clear on one question? If I've read your skeleton argument correctly, you are asking us to depart from Santen, but you're not asking us to depart from any of Pharmacia, MIT or YISA. Is that correct?
That's correct, my lord, and I will go on to explain why you don't need to depart from those cases in coming to the decision that we persuaded.
At that point, you will explain to us why that wouldn't simply plunge us back into the post-Neura chaos.
Of course, my lord. And so the basis for our submissions is that in Neura, the CJAU reached the correct purposive or teleological construction of Article 3D, whereas in Santen it was an overly literal approach, and it ignored the approach in the guidance in the explanatory memorandum. And one of the problems in our submission with the Santen decision is that this court did not have the benefit of arguments from the United Kingdom, and in particular the arguments put forward by the government in the Abraxis case, explaining how Neura was consistent with the earlier case law. And that's part of the reason that the Court of Justice fell into error in Santen.
Well, again, something you want to deal with in due course is the fact that, of course, the rapporteur was the same in both cases, and 3 of the judges in Abraxis also sat on Santen.
I will try to deal with that, my lord. And in the course of my submissions, I'll also address you on the question posed by the court during the preparation of this case and the effect of the Neuron decision. So what I intend to do is start off with the legislation and the explanatory memorandum, then look at some of the CJAU case law, which we've already dealt with some of it in our skeleton, then deal with Neuron, and then turn to the facts of the case insofar as they're relevant.
I think you can assume that we are reasonably familiar with Neura, Santen and Neuron.
I'm very grateful, my lord. I hope not to repeat myself, but there are some additional passages I'd like to take your lordship to. So, my lord, firstly, the legislation itself, which is in tab 22 of the authorities bundle. And I know your lordships will be familiar with this from previous cases, but we draw attention particularly to recitals 3 and 4 and the statement of purpose as to why the SPC regulation is being introduced. We acknowledge recital 10 and accept that there is a balance to be achieved. We say that an SPC grant in on the facts of this case is the right side of the line where the balance has been drawn. And then, of course, most important articles are Articles 1 and 3. And in Article 1, you'll note the definition of medicinal product, the definition of product, meaning the active ingredient in the medicinal product, and the definition of the basic patent. And those are obviously all important for both the remainder of the legislation and the case law, and the difference between these various definitions is important to retain in mind. And then Article 3, which the court is concerned with in this case, Articles 3A and C refer to just the product, but Articles 3B and 3D refer to, in addition, the medicinal product. And we say that's the way in which we distinguish the case law referring to product and the way in which we say the Court of Justice was right to understand Article 3D as allowing second medical use patents, SPCs on those to be granted. The other legislation which your lordships will be aware of also has some relevance is the plant protection regulation, which is at tab 25. And the reason for this being relevant, not only is it cross-referred to in some of the cases, but if your lordships go to recital 17, you'll see there's express cross-reference in recital 17 to some of the recitals of this legislation, and also, in fact, some of the articles being applicable to the SPC regulation as well. And in
Tab 25.
tab 25, yes. Recital 17 on page 454 at the bottom.
Pardon? Thank you.
And so there's express cross-reference to Council Regulation 1768 of 92, which is the original version of the SPC regulation. And in particular, your lordships will see in recital 13, which is one of those which is said to apply to the SPC regulation, it says that where the basic patent covers an active substance and its various derivatives, salts and esters, the certificate confers the same protection. But they then go on to say in recital 14, where the issue of a certificate consisting of an active substance, that does not prejudice the issue of other certificates for derivatives, salts and esters, provided that the derivatives are the subject of patents specifically covering them. So there, the legislators are expressly contemplating the issue of further certificates for patentable derivatives, such as salts and esters, but obviously we say that would include second medical uses where those are patentable as well. The other aspect, just while we have it open, in Article 3 of this legislation, Article 3, subsection 2, there is an express allowance for multiple SPCs to be granted for different holders. And again, that we see some reference to that in the case law. Then, if I may take you to the explanatory memorandum, that's tab 21. And again, I'm sure your lordships are familiar with at least some of this document. But in particular, I'd like to take you to, if I begin on page 3 of the internal numbering, so page 395 of the bundle. And the explanation in the introduction section for why the SPC regulation is being introduced, and in particular the last two paragraphs of page 395. Explains about the delay that is introduced by the requirement to obtain authorization. And then the first paragraph on page 396 explains that there was the introduction of the authorization legislation following the thalidomide experience, and the requirement to demonstrate safety and efficacy and the obvious importance of that for medicinal products. And then paragraph 3, a little bit further down, they explain that the requirement to obtain authorization to prove safety and efficacy imposes heavy penalties on pharmaceutical research. And then on the following page, in the middle of the page, in between the two hole punches, they say, the Commission takes the view that it is time to protect further new medicinal products, that it would be premature to make this process a measure of general application without having assessed the needs, etc. So note, in this explanatory memorandum, they're referring to new medicinal products, not new products, new medicinal products. And they go on in 4 to explain that this is not discriminatory, and the present proposal for regulation aims at guaranteeing laboratories working to develop, again, new medicinal products, a level of protection equal to that enjoyed by research in other sectors. And then if we turn over to pages 398 and 399, paragraphs 6 and 7 explain that because there are patent extension provisions in the USA and Japan, that gives companies in those jurisdictions an advantage and an incentive to research, and the purpose of this is to try to encourage resources to be centred in Europe and not in those jurisdictions. And then on page 8, there are the characteristics of the system are set out, paragraphs 10 onwards, and we place particular emphasis on paragraphs 11 and 12. Perhaps your lordships would just remind yourselves of 11 and 12. I think we both set those out in our skeletons. So again, if we can summarise, we suggest what 11 is saying. Again, it's emphasising new medicinal products, and it is saying that there is a limit to where a certificate could be granted, and only minor changes to the medicinal product, such as a new dose, the use of a different salt or ester, or a different pharmaceutical form, will not lead to the issue of a new certificate, even though it might be necessary in those cases to get further authorisation from the regulatory authority. But they go on to show it in paragraph 12 to explain when a new SPC might be available. They say the proposal is not confined to new products only. A new process for obtaining the product or a new application of the product may also be protected by a certificate. All research, whatever the strategy or final result, must be given sufficient protection. So we say that they have drawn a line here against new certificates for minor changes, but they also at the same time are explaining that research, there shouldn't be any discrimination against the research that is given protection. And we say that is consistent with the alignment with the generation of new patents. And you wouldn't normally get a new patent for a minor change, such as a new dose, the use of a different salt or ester or a different pharmaceutical form. But where you can get a new patent, and that's identified expressly by the plant protection regulation, as I've shown you, where you can get a new patent for a different salt or ester, you may be able to get a second SPC. And we say that is showing the legislators are keeping in mind the connection between the patent grant and the relevant marketing authorisation. Then if I can take you on to paragraph 16. And this is really, this is the point about there being a simple, transparent system. And this really is a point raised by my learned friends. They say, the danger with what the appellant is saying here is that it makes the system less easy to run by the offices, and that's a problem with it. We say not so. We say that the patent offices in this country are very used to identifying what a second medical use patent is, and we'll be able to tell whether something falls inside or outside the Neura exception, as we put it in the present case. So we say that although it is right that there is some guidance in the explanatory memorandum, what we're asking the court to do in this case would not contravene the guidance to keep it a simple, transparent system. Then, if I may take you to page 16, which is where they start to deal with the articles individually. And Article 1 is introduced in paragraph 28. And again, we see the express recognition in the middle of page 16, not only to product patents, but they say, however, it may be the medicinal product that is patented, meaning the active ingredient, the process by which the medicinal product is obtained, or an application or use of the medicinal product. So express acknowledgement that use patents can be covered. And then in paragraph 29,
What's the it in that sentence? It may be. What's it talking about?
I think it must be. I think they're acknowledging it's.
They're acknowledging that in the world of patents, you can patent a process, a use, or a product.
Yes.
But that's background to what they say in the next paragraph, which says that product has been chosen as the common denominator.
Yes, and we accept that product is important. The product is an important part of this, and the case law suggests that product should be narrowly defined, but we don't seek to challenge that as part of our appeal. Paragraph 29, they set out the types of invention which may serve as a basis for a certificate, and they say there are no exclusions. In other words, all pharmaceutical research, provided that it leads to a new invention that can be patented, whether it concerns a new product, a new process for obtaining a new or known product, a new application of a new or known product, or a new combination of substances containing a new or known product, must be encouraged without any discrimination. And note here, they refer expressly to a new application of a new or known product. So they are, having defined product in the previous paragraph, they are expressly referring there to a known product, a new application for that. So that must, we say, include second medical uses. It's a product that is known, so it's a product that's been approved, because that's what a product is. It's an active ingredient, and they are expressly contemplating here that SPCs are available for new applications of old products. And we say this is a key part of what the legislators were intending to achieve, and which is why we say Neura was correct in the conclusion it came to. Then we see paragraph 35 on page 19. And we see a reflection of what we saw earlier, which is that minor changes it will not lead to the grant of a separate certificate. But we say that doesn't override what they've said earlier, that if there is a new invention, a new patent, then it will be possible to obtain a further supplementary certificate for that new invention.
Those two sentences say, it occurs very often that one and the same product is successfully granted several authorizations to be placed on the market, namely each time a modification is made affecting form, dose, composition, indications, etc. So that's addressing, for example, the scenario of a second indication for a known product, is it not?
Yes, it is, my lord, but it's
it
not.
Says, in such a case, only the first authorization to be the product to be placed on the market in the member state is to be taken into account.
My lord, yes, but in the majority of cases where you extend the indication of a medicinal product, you're doing so still within the confines of the original patent. So you're finding another use for a different group of patients or a slightly different indication, but that's still generally within the confines of the original patent. And this, although it says that in para 35, that doesn't undermine what they've said in paragraph 29, which is that if there is a new patent, including a patent for a new application of a known product, then a certificate should be available in those circumstances. So it does turn on the facts, and we say the crucial fact is whether or not there has been a separate invention with a separate patent for a new indication, and that we say is covered by paragraph and contemplated by paragraph 29. And then in paragraph 36 on page 20, we see again encouragement of research into new medicinal products. There is an express acknowledgement that you shouldn't be able to get more than the 15 years that you are due for your invention, but of course that doesn't exclude you getting a separate patent and a separate 15-year period if you make a separate patentable invention, albeit involving the same product later. And again, in the second paragraph on page 36, we see the acknowledgement in the middle of the paragraph: a new certificate may not be granted for one and the same active ingredient, whatever minor changes may have been made, and that's again talking about the different salts, etc. It's giving examples of that, but it's not excluding the ability to get a new SPC for a new invention for second medical use. And then paragraph 40, we say on the following page, emphasises the link between the basic patent and the authorisation, and the requirement to have a basic patent and an invention in each of these cases. And we see 42, paragraph 42, finally, final paragraph I want to refer you to, the last sentence of paragraph 42. In the case of an application patent, the certificate will only be available to protect the use or uses claimed in the patent, provided that they were authorised prior to the expiry of the basic patent. So what they're referring to there is the limit on the protection that an application patent will give you. So if you get an SPC for a second medical use, you're only protecting that second medical use. You're not able to use that SPC to go back and prevent the first medical use, which by then will be off patent. So they are recognising expressly again the ability to get SPCs on application patents, and they're also recognising that there is a limit to that because the SPC limits you to both the what's in the authorisation, but also what is in the patent. And that, we say, is an important safeguard that prevents the Neura exception being used as a method of evergreening or as extending protection in a way which the legislators didn't contemplate. In other words, you're only ever going to get a maximum of 15 years for your invention because you are always limited by the terms of the basic patent and the invention that's contained within it.
What does the second sentence mean? 42.
I think that's saying that for a product patent, the patent itself doesn't limit you to any use. That doesn't limit protection to it. You get protection for all possible uses.
At the end of the sentence, but I don't understand what it means when it says in the case of a product patent, the limitation under the patent will not apply.
I think it means there's no effective limitation, but because you can use a product for anything. But of course, you're still limited by what's in the authorization. So your SPC won't prevent you using the active ingredient as a doorstop, because that use of a doorstop is not part of what's in the authorization. You've got the double limitation for the protection of an SPC, which is what's covered by the authorization, and that includes potential additional things that are added during the lifetime of the SPC, but you're also limited by what's by the claims of the patent. And so with a product, if you have a product patent, the patent covers any use of the product, but the authorization will only cover those uses which have been approved, and so the SPC will only go so far as to stop somebody also doing what has been approved up to the date of the end of the SPC. So there is this double protection, which we say has been built in and which again expressly acknowledges what the patentee has invented, and in the case of an application patent, is of course much more limited because the patent is only directed towards the specific use which is set out in the claims. So, my lords, in summary, we say that it's clear that the drafters of the legislation did wish to protect patented new uses of old compounds, including those previously the subject of MAs. What they didn't wish to protect was non-patentable extensions of MAs, and that's the reference to the minor changes that we see. And the reason that we say Santen is contradictory to the explanatory memorandum is because under Santen, there would never be any protection for the new use of old products. And that is expressly contrary to what is contemplated in paragraph 29 of the explanatory memorandum, amongst others. And indeed, my Lord Justice Arnold seemed to recognise this in his decision in Abraxis, and your Lordship did find support for the arguments in Neura in the explanatory memorandum. And we'll come back to that, and we say it is consistent, and there is the orthodoxy is in fact the Neurin line and not the overly literal approach in Santen, which we'll come to. So if I can turn now to the case law.
I've read somewhere, it said that the explanatory memorandum is a bit of a child of its time and was based on a model of pharmaceutical development which, from the perspective of 20, 30 years later, is rather naive. I don't know where I got that from, because I didn't make it up. I read that somewhere. I don't know
I haven't. I'm not aware of where your lordship's seen that, but it's obviously fair to say that this was dated 1990, and it may be the issues which it considered as applicable to the pharmaceutical industry in 1990 have moved on, and I don't think anyone would suggest that when they drafted this document they'd thought of everything, and in particular the use of combination products. Which, and your lordship may be aware that
well be where the context is actually.
yes, and your lordship, just while I'm on this point, your lordships may be aware that there is a reference on Articles 3A and 3C, the Teva reference, which is due to be handed down, the judgment of the court due to be handed down next week by the Court of Justice. That's been long awaited. The Advocate General's opinion came out some time ago, but just so your lordships are aware, there is ongoing case law in the Court of Justice, this time on Articles 3A and 3C. But if anything, my lord, we would say that second medical uses have become more important as time has gone on. And so if we're thinking of the always speaking principle and the fact that the legislation has to keep up with the times, we would say that those aspects of this document which refer to the new use of old products, in fact, come more to the fore as time has gone on, not less.
Now, obviously, we don't know what the court's going to say in Teva, but based on the AG's opinion, is it likely to affect our decision?
I would suggest not. There is a suggestion that there will be a bit of a recalibration of Mediva, but as we know, the court doesn't always follow the Advocate General, so I think it's probably unwise for me to predict whether that will happen, and if so, in what way. But I would respectfully suggest it's not going to make a difference. But of course, if I know your lordships will no doubt be keen to get judgment out, but whether or not your lordships want to wait until it's come out and ask us for any observations.
That's really what's behind my question.
Yes, and maybe my learned friend has some thoughts on it as well, and we'll perhaps think about it over the short adjournment. But I thought I should at least let your lordships know it's coming, just in case it makes any difference to your lordship's thinking. So, my lords, I was going to take you to the cases and try to focus on the cases which it is said in Santen are not compatible with Neurim, and try to show you why, in fact, we say they are. So, the first of those cases is Pharmacia. That's in tab 1. And my Lord Justice Birss may recall his involvement in this, although it is some time ago. The issue in Pharmacia was the distinction between human and veterinary use and the effect of the transitional provisions to the regulation, in particular Article 19.1. And in that case, the active ingredient cabergoline was doing exactly the same thing in both animals and humans. It was preventing lactation. So this wasn't a second medical use case at all. It was just a case that sought to draw a distinction between human and veterinary uses. And you can see that in the Advocate General's opinion, paragraphs 27 and 28 on page 7 of the bundle. Where the Advocate General summarised the issues, and it did come down to the question of whether there was any difference between human and veterinary use. Advocate General thought that it didn't. The other point, just to pull out from the Advocate General's opinion, at paragraph 38, where he makes clear the importance of the difference between the terms product and medicinal product. And he also emphasises at the end of paragraph 38, the purpose of the SPC regulation is to extend patent protection. And again, we say that it is important always to remember that this is at the interface of patent law and regulatory law, but you mustn't forget the patents and the inventions that are underlying the issues in each case. So I can just go straight, I think, to the ruling on page 16, paragraph 24. And this is the important bit for the purposes of this case. We say all that this ruling establishes is that under Article 19.1, that's the transitional provisions, a SPC for human use is precluded by an authorisation to place the product on the market as a veterinary medicinal product. And we say that's as far as this case goes, and there's nothing in that ruling which touches upon the decision that I'm asking your lordships to make this morning. Then we come to MIT in tab 2. And this was a case about asking what is an active ingredient, what is a product. And in this case, there was a active ingredient, carmustine, to treat brain tumours, and that was combined with a polypheprosan matrix, which was used to administer the carmustine. The carmustine had already been approved for the same indication without the use of the polypheprosan matrix. The matrix was inactive, but it enabled the safe delivery of the active, which was otherwise toxic, and so it allowed it to be used more effectively. Now, the Advocate General Leger, agreed with the Commission and thought that there should be protection for such a combination of active ingredient and non-active ingredient, because such research should be promoted. And you can see that in the passage beginning on page 30 at paragraph 48 onwards. So he thought that this sort of product was a good thing, and even though it involved the combination of a non-active ingredient with an active ingredient, he thought because that overall enabled treatment to be improved, that was a good thing and should be allowed. The court disagreed, and that is at tab 3. The reasoning is relatively sparse, particularly given that the court is disagreeing with the recommendation of the Advocate General. There's not much explanation as to why the court has gone in a different direction. but it seems to be focused on the wording in the explanatory memorandum, which refers to a product being an active substance in the strict sense.
Sorry, where are you?
I'm looking at paragraph 25.
25. Yes.
So they cross-refer to active ingredient in the regulation, and because polyphyprosan was not an active substance in the strict sense, they say, well, you shouldn't be able to get an SPC on this combination. And so we say that the ruling in this case is focused on Article 1B, the definition of product. It's also focused, as you can see from paragraph 29, on a desire to not create legal uncertainty. But we say no part of our appeal seeks to question the principles that are set out in this case. So Article 1B and the approach to definition of active ingredient is and remains, as far as we're concerned, a relatively narrow one.
So just to be clear, you say that the definition of product as part of your case is a narrow one down to active ingredient?
Yes, yes. Then we come to YISM, which again, it's a while ago, but this time both my Lords, Lord Justice Birss and Lord Justice Arnold may recall some of the facts of. This was a case about the topical use of calcitriol to treat psoriasis. And the point in issue was that calcitriol had previously been approved for oral use to treat hypocalcemia in patients with kidney failure and to treat osteoporosis. So
this was a second medical use case.
So we do accept that on the facts, yes, this is probably the most similar case to Neura or to the case before your lordships this morning. However, the important point about this case is that the question to the court was only framed in terms of Article 1B and was not framed in terms of Article 3D, which is, of course, the article before your lordships this morning. And the reason for this is the way in which the case was argued before the courts of this country. And interestingly, the case was framed as an Article 3D case before the hearing officer. The hearing officer rejected it, fine, that's accepted, but it was argued in that way, but for reasons which are not explained, the point was abandoned when the case came before my Lord Justice Arnold in the High Court, as indeed your lordship recorded in your judgment. And your judgment isn't in the bundles. I've got a copy. I've got copies I can hand up. If it pleases, it may not be in dispute. It may not be necessary, but
I think we ought to see.
Yeah, I'm grateful. So the relevant part of this, my lords, and I lost my copy.
Paragraph
It's
10.
paragraph 12, where your lordship set out what the hearing officer's primary case before, YISM's primary case before the hearing officer, and then you recall that case is no longer pursued, and you say it's unnecessary for me to set out.
Where are you reading from?
Paragraph 12, my lord.
12.
So the case as presented to the hearing officer was effectively the same as the case in Neura or the case today, that it's still the same product, but it was suggested that when you get to Article 3D, you're allowed to take into account the relevant marketing authorization, and that there was a different marketing authorization for calcitriol to treat psoriasis as compared to the earlier ones to treat hypercalcemia. That was abandoned. We're not sure why. It may be because the applicant could see the MIT case in the wings and could see that if they streamline themselves with the MIT case, and indeed the Advocate General at MIT, who seemed to agree that an SPC should be granted, that might be the easiest way for them to win this case. Unfortunately, of course, MIT went the other way, and so a reasoned order was given against them.
I'm sorry, Mr. Misson, this is now legal archaeology, even for those of us who were involved in this case. But if you're going to take this point, you're going to have to take it a little slow.
I'm sorry, Mark.
Because although you're correct to say that Lewison didn't advance the primary case which he had advanced before the hearing officer, you have to look at the way the case was argued, which is set out in paragraph 17, where Lewison's argument before me is summarised, and you're correct that the focus is upon Article 1B, but you have to look at how it's framed in subparagraph G. Product in Article 1B should be interpreted as meaning the active ingredient or combination of active ingredients, the subject of the invention of the basic patent. And that is, in essence, the exact same argument which subsequently prevailed in Neura.
Well, with respect, my lord, it's not. So what they were saying in this case, and your lordship set it out in paragraph 13, they said that the product in this case was calcitriol in combination with an ointment base, and to treat psoriasis. It was also part of that. So
I'm lost, Mr. Commissioner.
Sorry.
You told us you were looking at paragraph 13. That's the hearing officer's decision.
Sorry, I'm very sorry. You're absolutely right. I've taken you to the wrong path. That's my fault. That was the alternative case, which did go forward, and then the questions were withdrawn by after my lordship made a reference, and then.
Yeah, but that's later.
Yes, no, your lordship's right.
You're looking at the reasoning
Yes.
in the referring judgment.
Yes.
And in paragraph 15, the primary case is calcitriol for the topical treatment of psoriasis.
Yes, I'm sorry,
Although
I was
they
looking at the wrong
maintained
one.
the alternative case as a combination of calcitriol and an ointment base.
Yes. So what it was being said there was the product is calcitriol for the topical treatment of psoriasis. So they're trying to convey.
It's bringing in the use, which
Yes.
was the subject of the new patent,
Yes.
is the second medical use.
Absolutely, my lord. Absolutely.
That's why his lordship refers to a Swiss form patent claim, presumably.
Well, and then what happened was the Court of Justice said you cannot define your product by reference to the use, which is psoriasis in this case. Product is.
You're saying your case is to shoehorn this into 3D. This was an attempt to shoehorn it into 1B.
1B, yes, my lord.
That's what this is.
That's what this is about. They abandoned their 3D case and they instead tried to say that the product is calcitriol for a use. And the Court of Justice said, no, product is product. You just look at what is the active ingredient. And so the product here is calcitriol. And because, for that reason, you don't get your SPC, you never get as far as Article 3D. So, my lords, that's why we say Yissam, although similar on the facts, doesn't assist in determining the correctness or otherwise of Neurim.
We haven't looked at the Court of Justice's ruling.
Yeah, no, I'm going to come to that, my lord. Sorry, but the question went off as an Article 1B question, and we see that at tab 4. The reasoned order. And so the court issued a reasoned order saying you can't widen your definition of product And the reason they gave a reasoned order was no doubt because MIT had just been handed down, and so it was an entirely unsurprising result for the court to say that we've just told you what product is, it should be interpreted narrowly.
Can we just look at the question? Because 3 questions were referred and 2
Yes.
were withdrawn
Yes,
in the light of MIT.
yes,
The one that was maintained was question 1. And in a case in which the basic product protects a second medical application of a therapeutic agent, what is meant by product in Article 1B?
yes.
And I take that. And in particular, does the application of the therapeutic agent play any part in the definition of product for the purpose of the regulation? So, true it is that the focus was on Article 1B, but it did say for the purpose of the regulation as a whole.
Yes, no doubt your lordship had a broader question in mind with the question, but as we know, the Court of Justice sometimes wishes to confine itself to narrower issues when it answers. And so your lordship can see in paragraph 18 of the ruling that essentially the core part of the reasoning, it follows that the concept of product cannot include the therapeutic use of an active ingredient protected by a basic patent. That is not inconsistent with our case before your lordships. And then you see the ruling.
So let me just see if I've understood the argument. The argument is, yes, it's the same product, but it hasn't been, that product has not been authorized as a medicinal product for this use. Therefore, when you're looking at the first market authorization for a medicinal product, you can look at the use, even though it concerns a known product. That's
correct.
encapsulated.
And we don't dispute that the product in our case is cladribine, which is the same as the product that had previously been authorised. That's not in dispute. We're not seeking to challenge that.
So your case really all turns on the definition of medicinal product.
Yes, and the way to interpret Article 3D, the reference to medicinal product in Article 3D. So just to finish on this, although your lordship had asked the question in broad terms, the answer that came back was limited to Article 1B in the ruling. And again, we say that's not inconsistent with the case that we're running before your lordships today. Nor is it, so we say that Neurim is not inconsistent with any of Pharmacia, MIT, or YISM because of the way in which the court expressed itself in each of those 3 cases. So then we get to Neurim.
What do you say about paragraph 90, where they say the same interpretation can be inferred from paragraph of Pharmacia, in which the court held the decisive fact of the grant of the certificate is not the intended use of the medicinal product. And the purpose of the protection conferred by the certificate relates to any use of the product as a medicinal product without any distinction. And of course, as you've pointed out, that's about in the context of human versus veterinary. But doesn't that show that the court was conscious of the need for a consistent interpretation? Because here they're talking about the medicinal product.
I accept that they obviously say what they say there, and the second part of that sentence is a reflection of Article 4 and the protection that's given by the certificate. But that, as we've looked at in the explanatory memorandum, what they were seeking to do there was to say you can't get a separate certificate if you just extend your protection within the confines of the basic patent by getting a new indication. This doesn't address the grant of a second and new invention for a further use. Pharmacia didn't address that. This case didn't address that. And indeed, the first case which did address it is Neurim, which is the one I want to come to next.
Just to be, can I just check this, Mr. Mitchison? In para 19, the words from Pharmacia,
Yes.
you say they're either wrong or they don't apply when it says the decisive factor for the grant of the certificate is not the intended use of the medicinal product. Your case in this court is the decisive factor for the grant of the certificate is the intended use of the medicinal product.
For Article 3D and the facts of this case, yes. And there are other...
So you are saying that's wrong?
I'm saying that is a generalisation. It's an overgeneralisation because we see, for instance, the Forsgren case. The Forsgren case is all about, is the active ingredient an active ingredient because it is covered by the medicinal, by the authorization or not. And you have to look at what the indication is in order to decide that. And they say expressly in Forsgren, we need to look at what the indication is to decide that. So this generalization in paragraph 19, it might be true in general terms, but it's not true in every specific case, not in Neura and also not in Forsgren. And so, if anything, it's island hopping. I mean, one can pluck words out of a general statement where the court was not necessarily thinking about the specific issue, Article 3D, and we say it's just not right to apply that strictly to the different facts which are now before your lordships. So, my lords, we come to Neura, and if we start with my Lord Justice Arnold's decision in the High Court at tab 6, and the facts of this were that there was an active ingredient, melatonin. It had been approved to treat reproductive inactivity in sheep in the past. The new application was in relation to the treatment of insomnia in humans. And so on one level, it might be said, in fact, the facts were more similar to pharmacia in the present case because there was a veterinary and then a human element to it. But it's also right that it was obviously a second medical use, a different use in humans as compared to animals, unlike the pharmacia case. And as your lordship recorded at paragraph 7 of your judgment, the office refused the application on the basis of pharmacia, MIT and Yissam. And for the reasons I've been over, we say it was incorrect to do so because none of those cases touch upon the specific issue before the court in Neura or today.
Sorry, which paragraph?
This is paragraph 7. It's page 73 of the bundle. So we say that the office was wrong to do that because for the reasons I've been through. Then you go on to compare the two patents in paragraph 13, and you note that the patents do not overlap at all. Of course, we point out in going through this that there might not be a patent for the first authorization. The first authorization might just have happened without patent protection. But in this case, at least, there were two patents and the uses of the two patents did not overlap. Paragraph 14, your lordship records what was said by the Court of Justice in AHP, which is in the bundles, we don't need to go to it, but it's important, and this is the approach to the interpretation of the legislation, not solely on the basis of its wording, but also in light of the overall scheme and objectives of the system of which it is part. And then your lordship rehearsed the arguments of the parties and came down in favour of upholding the hearing officer's decision to refuse an SPC. And your lordship put it in paragraph 49 in terms of Yissam. You also addressed it in paragraph 45. You addressed an argument put before you that Yissam was of lesser authority than pharmacia because it was a reasoned order, and you rejected that. And then in paragraph 49...
46 is important part of the reason.
Yes. And again, your lordship's relying on pharmacia, MIT, and Yissam. And as we've been over, we say, your lordship, paragraph 49, you say Yissam is fatal to Neurim's case on this appeal. And we say, with great respect, your lordship was wrong because of the way in which Yissam was argued. It was not a 3D case at all. And the reason that Yissam was delivered as a reasoned order was because it was an Article 1B case, just like MIT. and that's why the court dealt with it in the way that it did. You also said in 49 you thought it was act clair against the applicant, though to be fair, you did grant permission to appeal. And of course, as we've seen, things turned out a bit differently in the Court of Justice. So if I can go on to the Court of Appeal decision in tab 7, and the reasoning of Lord Justice Jacob is at paragraph 15 onwards, and it's been said that this reasoning is powerful and persuasive, and we respectfully agree, and really we adopt all of it, all of Lord Justice Jacob's reasons up to 27. And so we have set out some of this in the skeletons. I don't intend to read it all out to your lordships, but we would highlight the following points. Firstly, the starting point is what is an SPC? This is paragraph 15. It's protection supplementing the basic patent. And so you've always got to keep the basic patent in mind and bear in mind what the invention is that it's protecting. Then he deals with the teleological interpretation. That doesn't appear to be in dispute. Then he deals with the cases relied on by the IPO. That's YISM, MIT, and Pharmacia. And he correctly says in our submission, respectful submission, that those cases should all be seen in the context of their own facts and the nature of the questions referred to them.
Where are you, Mr.
Paragraph 17, my lord.
17.
Sorry, perhaps I'm going too fast.
No, I see. Yes.
I don't want to rush this because this is important reasoning. So he distinguishes the previous authorities based on the facts, their facts, and the questions that were referred. And he says what the court said should not be taken wholly out of context, as to apply to a case such as this present, such as the present, when there are two patents of non-overlapping scope. Their argument is that the basic principle is one SPC for one patent. And we say, again, this is important. And he refers to recitals 13 and 14 of the Plant Protection Regulation, which I showed you, which expressly contemplates that you can get a second SPC for a further invention, such as an ester or derivative, where that ester or derivative is itself patentable. And so he concludes at the end of paragraph 18, each patent can have its own SPC, but only one. And the relevant MA for that patent is an MA for a product falling within the scope of that patent. And that, of course, is key, we say, to the proper understanding of Article 3D. Then he referred to the Hogan-Lovells case and the reference by the court to the importance of the link between the basic patent and the MA. We say that's right. Then he goes on to deal with the explanatory memorandum, and he deals with paragraph 36, which we've already looked at, and he emphasises in end of paragraph 21, it's only minor changes which don't count for a new SPC, as I've sought to submit to you. And at the bottom of the page, paragraph 22, he says, Neura says this shows a clear intention that there can be one, but only one SPC for a particular patented product. The SPC now sought would indeed be the first SPC for its patented product, and the first MA for that was 2007. Then he goes on to deal with how this is works into the interpretation of the regulation, and he says it needs to be the first relevant authorization, and by relevant he means connected to the scope of the basic patent.
What do you say to the point that that's reading into the legislation words which simply are not there?
Well, we say this is ordinary principles of construction, my lord. You take the purpose of the legislation, and which is expressed in the explanatory memorandum, and you then had to interpret the effect of Article 3D. And it is right, I accept that on a literal interpretation of Article 3D, that wording and that meaning doesn't come out. But that is not how you construe legislation. you construe it purposively. And when you have the purpose in mind, it is right for the tribunal exercising powers under the regulation to have in mind the principle that each patent is entitled to an SPC, and therefore, if the authorization is the first authorization falling under that patent, then that is how Article 3D should operate. So,
Yeah, at the last bit of 93, just the end of Para 22, it shows, it says, what just Jacob was saying, Neura says this shows a clear intention that can be only one SPC for the particularly patented product. The SPC now sought would indeed be the first SPC for a patented product. Isn't this in fact, although it doesn't say it, reading Article 1B, reading the use into the definition of product? Isn't that what that is doing?
well,
Isn't that what in fact the approach to interpretation is doing? Is in order to make it work, is reading the use into the definition of product.
well, we submit not, my lord. We submit you still consider product as product per se, and in its limited way. But when you get to Article 3D, which is not just referring to the product, but refers to the first marketing authorization to place the product on the market as a medicinal product, that is when you're entitled to look at whether or not this is the first relevant marketing authorization. So it's not an argument about product. I'm not seeking to expand.
I'm just thinking what Lord Justice Jacob said when he emphasised the italics on the word patented product. The only way that, as far as I have to say at the moment, the only way I can make sense of reading that, I don't mean that's a disrespectful sense, what I'm trying to understand what was being said there, that is to qualify the word product, not medicinal product, with an adjective. What that adjective is doing is reading the use in the patent into that definition of product. That's what that does in that sentence, isn't it?
Well, it depends. I understand your lordship's point that it could be said that he is expanding, but it depends whether you think he's talking about Article 1B here or he's talking about Article 3D.
Well, he's obviously talking about 3D.
That's
He says that's how 3D should be read.
yes. So he's not suggesting that product should be interpreted differently in Article 1B. It's it's the danger of trying to take words that are expressed in general terms in that sentence, but he's seeking to apply it to the facts of that case. And we say that it doesn't mean that product in 1B has to be, the meaning of product in 1B has to be expanded, or that he's suggesting
You accept, as I understand it, that when we come to Article 3D, product has the same limited meaning.
it does.
So
Your argument really turns, doesn't it, on 3B. You've got product X, and it's authorised as a medicinal product for treating condition A. And so you read the definition of medicinal product as meaning any substance, substance X, presented for treating or prevented disease, condition A. And then when you get to 3D, you ask yourself, is that the first authorization of product X for treating condition A on the market?
That's correct, my lord. We obviously accept that it needs to be.
You now come along with same product X, but you want to do it for condition B. You say the authorization, the market authorization doesn't authorize product X for condition B. Therefore, your application is a different medicinal product, and the authorization is the first for that product and use.
Correct.
That's the way your argument
Yes,
goes.
and the key to this is that it's not an open door to every time someone gets a new authorization, they're allowed to get a new SPC. They have to get a patent for it as well. It has to be a new invention, and that's what guards against this becoming any sort of abuse. But your lordship's absolutely right, and of course the wording of
But the patent point is dealt with by Article 3A.
it is. But you also have to understand the whole legislation as being an integration of law on authorization and the law on patents. And the explanatory memorandum seeks to say that you should be, there's no discrimination, all types of invention should be, in theory, capable of getting an SPC, including expressly the new use of an old product, which is precisely what we're dealing with here. So we say it is all a piece. And I respectfully agree that, of course, because 3D refers to 3B, there must be some link between.
So, I mean, effectively, what you're saying is Lord Justice Jacob shouldn't have read words into 3D. He should have concentrated on 3B instead.
Well, yes, it probably comes to the same thing because they're related. But yes, and of course,
still involve reading words into 3B, wouldn't it?
well, it does, my lord. But that's what purposive construction is. And as I say, I accept I lose if it's a literal only, I lose. But that's not how you construe legislation.
Yeah.
So we were dealing with paragraph 23 is where Lord Justice Jacob set out what he thought the test should be. And then he says only such a reading could fulfil the basic purpose of the regulation. It's implicit that the MA must be within the scope of the basic patent. Moreover, in none of the cases relied on by the controller, in particular MIT and YISM, was the court asked to consider the meaning of authorization within the context of Article 3D. We say also the same for pharmacia, and therefore all of those three previous cases, none of them are inconsistent with the ruling that then followed. And then finally, we see paragraph 26, and we do note, although it's not a central part of our case, but we do note that the court has also made clear that you can get more than one SPC for the same product if you have different patents, and that is entirely consistent with saying you can also get more than one SPC for the same product for different patents where there are different uses. So we say that the ruling in Biogen is also consistent. So then Lord Justice Jacob went on to explain why he was making the ruling.
The key paragraph for your purposes is 28.
Yes.
Because thus far he's just been setting out Neurim's argument.
Yes. But then he says why he's making the reference. He refers to the EPC 2000 in paragraph 29, and then he says in 30, in short, if Neura were wrong, then the regulation will not have achieved its key objects for large areas of pharmaceutical research. It will not be fit for purpose. Whether that is so or not is clearly a matter for the highest court. So off it goes to the Court of Justice, and we see that in the following tab 8. Your Lordship will have seen Advocate General Tristignac, who gave the Advocate General's opinion in Mediva. The court included Conrad Schiemann, amongst others. And then, so if I can pick up in the Advocate
Just
General.
before we get into it, is my recollection correct that neither the Advocate General nor the court refers at all to either Pharmacia or MIT or YISM?
In the text of their decisions, I think that's right, my lord. But given the importance which Lord Justice Jacob had given to those cases in distinguishing them in his judgment, given the representation before the Court of Justice, and we see that on page 100 of the bundle, you can see it was Miss May for the Treasury Solicitors, it was Ms. Samanada for the Commission, and although we haven't got the UK submissions before the court, I'm sure we can get them, but it would be incredibly surprising given that representation and the references to YISM, etc., in the judgment referring the case, that the Advocate General and the court hadn't had those cases in mind when they came to their decision. So, of course, I accept on the page, we can't see those, but to suggest that they weren't part of the reasoning and thinking, we suggest would be surprising.
They can't have been unaware of them, but how can you say it's part of the reason when they're never mentioned?
Well, maybe they thought they didn't need to mention because they weren't cases which dealt with the same point for the reasons I've given this morning, Mark.
They don't say that.
They don't say that. No, I accept So, Malloy, if I pick it up, please. First of all, the AG's opinion in tab 8, where we are, and paragraph 19. Your Lordship can see, having set out the question, the Advocate General says, this question has not yet been answered definitively by the court in its previous case law, and there are valid arguments both for and against the possibility of obtaining a supplementary protection certificate in a case like the main proceedings. And then she goes on, she footnotes Synthon and Merck. Now, we say she was right to say that this question had not been answered definitively by the court in its previous case law, because none of MIT or Pharmacia or ISM answered the same question. They were all dealing with different articles under the regulation. And well, Dr. Selmy reminds me, footnote 38 of the AG's opinion on page 114, she does footnote Pharmacia there. So she has at least referred to that case in the course of her opinion.
Thank you.
And so the way that the Advocate General deals with it, she first of all looks at the literal interpretation, and that's paragraph 21 to 27. Then she goes on to look at the scheme and objective of the regulation, paragraph 28 onwards, and in particular in paragraph 34. She notes that an active ingredient can form the subject matter of more than one different patent. And so she notes at the end of paragraph 34 that in principle, Article 3A permits the grant of more than one supplementary protection certificate for a product. She says the same applies under Article 3B. And so at the end of 35, she said Article 3B also permits in principle multiple supplementary protection certificates for products which are used as active ingredients in different medicinal products. And then in paragraph 36, she goes on to deal with Article 3C. And again, that's the Article 3C is where the plant protection regulation kicks in, and it tells you can have multiple SPCs for different holders. So she is noting that all of Article 3, or all other sections of Article 3, do allow for multiple SPCs for the same product. And therefore, obviously, we say it's not inconsistent with that to grant multiple SPCs for the same product under Article 3D, where there is a different patent for a new medical application. Then she goes on to deal with the teleological interpretation, paragraph 38 onwards, and she agrees that more than one supplementary protection certificate for a product should be possible under certain conditions. That's purposively interpreting the regulation. In particular, in paragraph 43, she says there is no inherent problem with that because there is still the 6-month limit to apply for your SPC. And in 45, she says, in this overall context, Article 3D of the regulation does not, in my view, seek to preclude without exception the grant of an SPC based on a second medical use. In 47, she notes the facts of this case, that there was a second medicinal product for human use for which a patent was granted. And then in 48, she notes the importance of this kind of pharmaceutical research. And she also notes the increasing importance of this kind of pharmaceutical research in industry, and I don't think that would be disputed today either. Then she goes on to refer to the EPC 2000 in 49 and the explanatory memorandum in paragraphs 50, 51 and 52, and she says that her overall interpretation is supported by the explanatory memorandum for the reasons we've given. Then she draws all this together in section 3, and she notes in 54, 55 that there is no evergreening by virtue of the allowance of second medical use SPCs, and so there's no problem with the exception that she is going to approve, because it is still dependent upon the first authorisation of that product and that use, and you don't get back protection for the previous use, which is different. Finally, she reviews some of the case law, and she says there are 2 strands. This is paragraphs 58 to 64, and she refers to Mediva Georgetown in 60, AHP in 61, and then she refers to the stricter line of case law, synthol and generics, in 63 onwards, and she says that, in her view, the interpretation of Article 3D is consistent with the Mediva Georgetown AHP line of case law, where you get, and this is important in 64, one and one only supplementary protection certificate may be granted for each basic patent under the conditions referred to in the regulation. And this really is a key part of Lord Justice Jacobs' reasoning, key part of her reasoning, and we say a key part of an proper understanding of the explanatory memorandum. So that is the AG, and then of course the court follows. It is, as usual, more concisely expressed, but the key parts are clear. For instance, paragraph 19, where the court draws together both Articles 3B and Articles 3D, and says there is a link between those and the basic patent referred to in Article 3A of that regulation. So entirely consistent with the observations that my Lord Justice Lewis has just put to me. And then in paragraph 22, they set out the principles underlying the SPC regulation to encourage pharmaceutical research, and they refer to Mediva and Georgetown. And then in paragraphs 24, they refer to paragraph 29 of the explanatory memorandum, which I have taken.
Just go back to paragraph 18.
Yes, of course.
It looks at the way the court reformulates the questions. In essence, whether the provisions of Articles 3A and 4 are to be interpreted in meaning, in the case of the present, the existence of an earlier MA for a veterinary medical purpose, which would preclude grant of an SA for the product application. So they are looking at it as a whole.
They are. Yes, my Lord, they are. Correct. And so, and it's fair to say that the order, the order that they make and the ruling they make is more limited than some of the suggestions made either by Lord Justice Jacob or indeed by the Advocate General, because they limit the effect of this to second medical use patents, and they expressly say it is just in a situation where there is a different application of the same product for which a marketing authorization has been granted. So they don't say every time you get a separate patent, you get a separate SPC. That would allow potentially for SPCs on formulation.
I'm a little puzzled by that. Paragraph 27.
Yes.
Articles 3 and 4 of the regulation are to be interpreted in the case such as that main proceedings. The mere existence of an earlier veterinary medicinal product does not preclude the grant of an SPC for a different application of the same product.
Yes. So it's the different application there. They're referring to the fact it's being given for a different use, unlike Pharmacia, which was the same use. This is for a different use. And so their ruling is confined to second medical use patents. And so it's not part of, I don't need to stand here today and say that we're asking for all patents, including formulation patents. That's a different case, and that may come before you on a different occasion. Obviously, came before the Court of Justice on a different occasion in Abraxis. But
The reason why this matters, isn't it, is because the interpretation of Article 3D that you're urging on the court would, on the face of it, apply to all these other cases.
well, it
There's
depends.
no good saying by fiat it doesn't. I mean, the interpretation, this is relevant. Putting the word relevant in works just as well if you're talking about proliferprosan in MIT or a different formulation or anything. It's the same, isn't it?
Well, it depends on how you interpret the explanatory memorandum. We say that,
I'm talking about the way you interpret the SPC regulation.
yes, in principle, your lordship's of course right, and then we have to deal with the fact that there is said to be a balance, and so. But I'm not seeking to persuade you one way or the other today that it goes beyond second medical use patents, because then I'd have to address you on Abraxis as well, which I don't have to, because we say Abraxis isn't inconsistent with the course which I'm asking your lordships to take today.
But your court, as I understand it, what you're asking us to do is to say the law is as in Neura, which is limited to second medical use.
My lord, yes, that's all I'm asking you today, because of course my SPC is limited in that way.
And just, that's what I've understood. The point I was putting to you was understanding that is what you're asking us to do. My question was intended to hear what you had to say about the fact that there's a problem with trying to limit it in that way.
Well, the problem arises because there have been statements by the Court of Justice saying that not all research is which gets a patent is deserving of an SPC, and so you have to try and interpret that and say, well, there's a limit, apparently a limit somewhere. Now, I don't seek to tell you where that limit is. It's not part of. I don't need to do that today. I accept that's maybe a more difficult question, but we say, as far as your lordship is concerned, all you need to decide today is that it encompasses second medical uses expressly, because second medical uses are contemplated within the explanatory memorandum.
Can I put my lord's question in a slightly different way? Given that the whole basis of this interpretation is reading in the words within the scope of the basic patent, that would be true whatever type of patent it is. It would be true if it's second medical use, if it was for a new formulation, or if it was for active ingredient plus some supporting ingredient.
Yes, it would, and of course that latter example you give, it's absolutely clear you can get a second SPC for a combination, a new patentable combination. If
it's a new combination of actives.
If it's a new combination of actives, absolutely you can get. So you can have active A to treat X and active B to treat X, and if you get a patent for A plus B to treat X, the same indication, because it's, say, synergistic, you absolutely can get a second SPC. So again, that seems to go further and is more generous, one might say, than the circumstances in which the controller says the line should be drawn today. So, and I accept that.
But it's a different product.
Well, it is, and it's patentable, and I accept that that's.
I've got a pot of tea in one hand and some milk in the other, and I put them together. I've got a different thing from what I had before.
Well, yes, and it may be the problem is overblown because, of course, there are maybe not that many valid formulation patents, and so maybe this problem is not a great problem. But I, of course, accept that on the wording of on the reasoning of the Advocate General, she seemed to think that all patents where you had a second patent, you should be able to get an SPC, and she may or may not be right.
Well, to be clear, if we go back to what Lord Justice Jacobs said in the referring judgment, paragraph 23, which we were looking at earlier, and the reason for doing that is one sees very clearly the interpretation that was being urged by this court upon the Court of Justice. The authorisation referred to in B is the first relevant authorisation, i.e. authorisation of a product within the scope of the basic patent. And that if that's how you read it, that applies to all types of basic patents, whether they be second medical use, new formulations, or whatever. I think you accept that.
I do accept that, my lord. I accept that. I'm not saying that all patents should or shouldn't be included in the SPC regulation. It may be that's an argument somebody else has to make on another occasion. All I'm saying today is that
Yes, but how do you get out of the words just this is okay for second medical uses, even if it's not okay for anything else? Because the process of interpretation, you've already accepted very candidly that you lose on the literal interpretation. So you're looking for a purpose of interpretation. But the purpose of interpretation is built upon the what the Advocate General calls a theological interpretation of the legislation. And one can understand how it works if you say, well, it must mean within the scope of the basic patent. And that's the argument that was being articulated very clearly and forcefully in Lord Justice Jacobs' judgment. But as soon as you say, well, it may depend upon what type of basic patent, how do you get that out of the wording of the regulation?
I accept you can't get it out of the wording of the regulation. You can only get out of the explanatory memorandum, which we say is clearly supportive of getting second medical use SPCs, but where it is less clear where the line is to be drawn between further dosage regimens or further formulations, because those are referred to in the explanatory memorandum as not deserving separate protection, but the explanatory memorandum doesn't say what happens if you are able to get a second patent on those uses. And we also have to bear in mind that there is overall meant to be a balance as reflected in recital 10. So it's not just the pharmaceutical industry, it's also patients and national bodies paying for drugs who need to be considered. So that is why I say there may be different considerations which might be argued in relation to a submission that said every single patent should be deserving of protection. But we say that's really for another day, and I shouldn't be...
Yeah, so it comes down to this, that what you urge upon us is a purposive interpretation having regard to the explanatory memorandum, which you say supports the proposition that it was the intent to protect patents for new indications, i.e. second medical uses, but not, e.g., new formulations.
Well, I'm neutral on new formulations, Lord. I'm not saying it doesn't, but it's less clear about new formulations. And indeed, I think your lordship in Abraxis, we're going to come to that in a moment, said that you could see that the explanatory memorandum did support the use of the allowance of SPCs for second medical uses. And so I think it's not just my submission, and we'll see when we come to the UK submissions to the court in Abraxis, we'll see they also drew a distinction between second medical uses and other.
Yes.
Can I ask a follow-up to my lord's question, which arises out of my own ignorance? I think I understand the functions and limits of explanatory memoranda in interpreting domestic legislation, but what is the status of such a document in interpreting EU legislation?
Well, that is, of course, a very good question, my lord, and we're in this strange world where we're treating it as assimilated law, but it was actually drafted in the EU. And so it's not quite possible to apply pepper and heart.
It's not so much pepper and heart, because we're not talking about what was said in the legislature. It's perhaps more akin to a white paper in domestic terms.
Yes, it's a paper by the Commission, who were the promoters of the legislation in that sense. So for consistency, we would suggest that the court should give it the same weight that the European courts gave it when they were construing it. But I do accept this is novel territory.
Well, can I ask the same question a different way? Are you suggesting that we should approach this question in a different way to the Court of Justice?
No, I don't think I am. I don't detect a difference in approach between the interpretation of domestic legislation and EU legislation in these sorts of cases.
The problem with that is that, as you accepted in answer to my Lord Justice Arnold, you can't get your interpretation out of the regulation. You find it in the explanatory memorandum. So your argument promotes the explanatory memorandum to effectively a document having the force of law.
I wouldn't go so far as that, Lord, with respect. I'd say that you have to interpret the legislation purposefully, and the place you get the purpose is from the legislation, obviously, but also from the explanatory memorandum. I'm not seeking to rewrite the legislation, but we say that what the Court of Justice has done in Santen is to completely ignore the purpose. And they expressly say we're going for a literal construction, and that's wrong, we say. We say that's just not how you should construe this sort of law. So, my Lord, that is Neurim, and we say it's not a surprising result when compared to the other allowable results within the regulation. And I've given you the example of combination of active A and active B to treat the same disease. You can get an SPC on a patentable combination of the two to treat the same disease. And if that's right, why shouldn't you also get an SPC for an old single active to treat a new, different disease, which is patentable, and some may say it is of considerable value to society to encourage this sort of research, particularly at a time when the number of smaller molecules is diminishing and the ability of the pharmaceutical industry to repurpose existing molecules is becoming more and more important.
Something's been bugging me for a while, which relates to what you just said, if you don't mind. The part of the case seems to involve the fact that there's no overlap between the first patent and the second patent.
Part of the Neurim case did, yes, my Lord.
What I'd like to understand is whether your case works just as well if the first patent was a general product patent. So that you have a patent on the compound, there's a pharmaceutical use, so the marketing authorization is for hairy cell leukemia, for example. Then you have a second patent, which is for a use. That use would, using the product would infringe the first patent as well as the second patent. So how does the interpretation of Article 3D work to your advantage in a case like that? Doesn't it break down if the first patent is a conventional product patent?
Well, the first point is that the SP...
The facts of Neurim.
Yes.
That's highlighting a slightly, if I may say so, unusual aspect of the facts of Neurim.
Right, but then we get into Article 3C and whether you can get a second SPC.
No, I'm talking about two patents. You start with a product patent.
Right.
All patent is a general compound patent.
Yep.
The second patent is a use patent.
Yes.
And what I'm not understanding is how which is a pretty conventional state of affairs. I'm not understanding how your way of getting yourselves a second SPC on the new use works in that context.
Because there's no overlap between the marketing authorizations.
Right. You say that's enough.
That's enough. And as long as
even though there is an overlap between the basic patent.
Yes, because there may or may not be a patent, as we see.
I understand there
yes.
may not be, but,
yes.
but there would be. We're talking about a case in which there's a second SPC. So there would be an original patent, which was a broad one.
Yes. Well, if there's a second SPC, then that engages Article 3C.
I'm talking about you trying to get a second SPC, I mean.
Yes, but if somebody had already got an SPC on this product, then and we were trying to get a second SPC on this product, then that would also engage Article 3C.
We'll never mind the second SPC. Imagine there was a product patent and a marketing authorization to treat something, and then you come along much later with a second patent.
Yes.
On a new use, but an old compound.
Yes.
And a second marketing authorization. You say that still works on your interpretation.
That still works because the as long as there's no overlap between the authorizations. That's the key point. So you can't re-SPC it where there's an overlap.
We're interpreting authorization by reference to the scope of the basic patent.
Yes, you do it. You do it by well, the protection. It follows that you can't have, because the basic patent wouldn't be valid if the previous authorization overlapped it. That's the point. So it comes to the same. You're asking for, it has to be the first MA which gives you the protection that the basic patent is setting out. So if the previous MA had given you an authorization to do something within the scope of the basic patent, that wouldn't be the first MA. So that's why the two interact with each other, and then there are various ways you can express it, but it comes down to the same point, which it has to be the first MA for that use. And so in my Lord Justice Birss' example, the original MA doesn't cover the use which the second MA gives, and so it's only the second MA which is the first MA to protect the use which the basic patent provides. So, my Lords, next in time comes the GlaxoSmithKline case in tab 10. We only need to go to this very briefly. This was a reasoned order. It was a case where there was an active and an adjuvant, and the question was, can you get protection for the adjuvant? And the court said no. And the only reason to show you this is in paragraphs 43 and 44, where, as part of the reasoning, they say that they don't think that Neura is incompatible with MIT. And we say that they were right to do so. And that's consistent with the submissions I've been making to your lordships this morning. So that's GSK. Tab 11 is Forsgren. And this was a case where the vaccine was to prevent pneumococcus, but there was a carrier protein in the vaccine called protein D, and the carrier protein was in fact active and had been derived from the influenzae bacteria. So the carrier protein was an active to treat H. influenzae, but it was not an active to treat pneumococcus, for which the MA was granted. And once again, we see the court linking the concepts of the MA and the patent. And if your lordships would just look at paragraphs 34 and 35. So what the court said that you shouldn't get an MA where the active, the protein D, was not active in the way in which the marketing authorization contemplated, because the marketing authorization was limited to pneumococcus. And if your lordship just read 34 and 35, please. So here, once again, the court is considering that Article 3A may be of some relevance. And then at the last sentence, they say, consequently, an active ingredient whose therapeutic effects do not fall within the therapeutic indications for which the marketing authorization was granted may not give rise to the grant of an SPC. So it is necessary, in some circumstances, to look at what the uses of the product in order to decide whether the active is a relevant active. And of course, you look at the use by looking at the marketing authorization. And so we say this is consistent with Neurim and consistent and inconsistent with the general statement that we've looked at earlier, where the court has said you never look at the use when you're trying to focus on what the product is, because this is a case where they did look at the use in order to reject the argument that the product included protein D. And so that is a specific requirement on the facts of this case under Article 3B. Then we come to Abraxis.
Just about the meaning of the word active. I mean, active is a word about use. You know whether something's active, you do have to know what it's doing.
Yes, you do. Yes, so it's still
The fact that protein D had some other activity doesn't mean it's an active ingredient in the context of treating.
I agree. But it's also true that you have to look at what the use is to decide whether it's an active. So it's not expanding the definition of product or active ingredient, but it is, in some circumstances, it's relative to what that active ingredient is doing, or whether it's an active ingredient. So I agree entirely with your lordship. Then we come to the Abraxis decision, and this was the paclitaxel combined with albumin or egg white to form nab-paclitaxel, which improved the delivery of the paclitaxel. And the specific question which this case brought was whether Neurim extends to formulations, including the nab-paclitaxel formulation in that case. But of course, it's important, or perhaps important, that in that case, the paclitaxel was being used for exactly the same indications as it had been previously been used for. So it was still treating the same disease, it was just an improved method of delivery for that disease. And this came before your lordship, my Lord Justice Arnold, tab 12. You went through the case law, now familiar, and you made your reference in paragraph 6, gave your reason for making the reference in paragraph 62. You said it wasn't clear how far the reasoning of the Court of Justice in Neurim extends. And then in paragraph 63, you provided your answer to that. You note that Neurim is limited to the formulation of old active ingredients for new uses. And you go on to say, right at the end of 63, you say, I agree with the controller that paragraphs 11 and 12 of the explanatory memorandum appear to indicate that SPC should be available for new applications, i.e. new therapeutic uses of old active ingredients, but not for new formulations. Accordingly, I would answer the question no. So before you, and indeed the Court of Justice, the controller was arguing that Neurim was justified on the basis of the explanatory memorandum, but an extension to formulations was not justified on the basis of the explanatory memorandum. I'm going to show you precisely what the controller said before the court in a moment. Tab 13 is the Advocate General. It's fair to say that the Advocate General didn't support Neurim in the reasoning here, but the court was more measured in tab 14 and rejected only the contention that the new formulation with a new accompanying marketing authorisation should permit an SPC. And you can see the reasoning of the court at paragraphs 38 and 39 on page 232. And then paragraph 43 on page 233. And in my submission, it's clear that the submissions of the United Kingdom to the Court of Justice influenced the decision of the court not to follow the Advocate General, but to uphold the ruling in Neurim.
Don't follow that because the submissions would have preceded the Advocate General's opinion.
Yes, but my suggestion is that the court preferred the submissions of the United Kingdom amongst others, and didn't, for whatever reason, didn't follow the Advocate General in when it came to its conclusion. And can I show you, to make good that submission, what the UK was saying to the Court of Justice, and that is at tab 3 of the supplementary bundle.
Yes, but hold on a bit. I think we need to be a little clear about this, because it's important when we get to Santen. So if you look at 15,
So look at
paragraph 15.
Yes.
Judgment,
Yes.
Abraxis.
Yes.
The Advocate General bases opinion on arguments not debated between the officers of Abraxis as a submission, and in his opinion, he proposed a departure from Neura or the limitation of that case.
Yes. And then they went on to reject
So
the request
they-
to reopen,
Exactly so. Exactly so.
because they said the Advocate General can say what the Advocate General likes, and effectively the court will determine it on that basis. That's in paragraph 16.
So what one gets from that is that by this stage, the court was conscious of the possibility that Neura might or might not be departed from, because the Advocate General raised the question. But in the event, they didn't feel they needed to address that.
Correct.
Whereas they did address it in Santen, which of course was pending at that time.
Yes, Arnold.
This was not a grand chamber formation, whereas Santen was a grand chamber formation.
Yes, I mean,
And the convention in the Court of Justice is that departure from previous case law is a matter for the grand chamber and not for a chamber of 5.
well, that may be. Certainly the convention is that the Grand Chamber hears more important cases. But as your lordship rightly noted in Yissam, there is no difference in the weight of a ruling, whether it's by reasoned order or by a court of 3 or a court of 5. It's still a ruling. It may be that the reasoning is more refined in a larger court, and it may be your...
No, what I'm doing is looking at the relationship between Abraxis and Santen.
Yes.
And bearing in mind, as I observed earlier, that the rapporteur was the same in both cases, and that 3 of the 5 who sat in Abraxis also sat in Santen.
Yes. But as we also know, the larger the court, the more difficult it may be for everyone to agree, and it may be
They
that
don't
they're...
have to.
No, they don't, but the reasoning
It's a
may be...
majority vote, as it
Yes.
is with any other multi-member court.
Yes, but as your lordship has noted before, I think in relation to the Mediva judgment, where you have a Court of Justice saying, for these reasons, and the reasoning above was rather sparse, it may be because they couldn't agree on the reasons, and so they kept crossing out. No, I accept that, my lord, but if you're trying to understand the underlying reasoning, then it may be a larger court is not actually as easy to follow. It all depends on how much has been put into the judgment to explain the conclusion that the...
All right. So, I'm sorry, I interrupted you.
2 things, if I may, Mr. Mitchell. Paragraph 37 of the court in Abraxis does indicate a narrow interpretation of 3D.
Yes.
My second question is nothing to do with the merits of the case, but how are we doing for time? Have you agreed a timetable with
I've indicated to my own friend I'd hope to sit down at about 12:30, depending on incoming fire.
Well, I know we've asked you a lot of questions.
I'm still hoping to sit down before, but maybe may slip to
Don't rely on that
12:45.
clock, it's
No.
not working. It is now 12:15.
Yes, I hope to sit down with enough time for my own friend to start before lunch. I'm grateful for keeping me going. My lord, so I was going to show your lordships the UK submissions, and the reason for doing this is because we say it's consistent with our submissions today, which is significant. It's consistent with the reasoning of the Court of Justice in Abraxis, and they are inconsistent with the Court of Justice in Santen, and we say that's because the Court of Justice didn't have the benefit of these submissions in Santen, and the Court of Justice fell into error by ignoring or not considering the various arguments that were put forward by the UK in Abraxis. So it's supplementary bundle tab 3. And this is Mr. Nicholson for the UK government. And we see at paragraph 7 on page 106, paragraph 6 on it.
Get any further? I mean, I'm taking it the fact that we have this in our bundle, there's no objection to us having these documents. But the normal rule is that observations of member states to the cause of justice are confidential, even after the case is closed.
My lord, yeah, we asked the controller if we could have a copy of this document, and it was provided without any conditions of confidentiality attaching to it.
I'm grateful for that explanation, but of course, what you can't give us for that reason is all the other submissions.
No, we have the commission submissions as well. They're in the following tab, which were also kindly provided by the controller.
Well, all right. Did the controller have the commission's authority to do that?
Well, I wasn't going to refer to them, so maybe it doesn't. That's not going to cause a problem. But, and it probably isn't time to have the debate about whether or not these sorts of things should be confidential.
That's a vexed question, as I'm sure you know.
Indeed. So, my lord, paragraph 6 sets out the question, and then paragraph 7 concisely sets out the UK's position that the basic patent, if the basic patent is for a new therapeutic application, SPC should be allowed, but the exception should not go further than that. In paragraph 10, the UK explained that they do consider that Neura can be reconciled with the previous cases, and also by reference to the explanatory memoranda. So perhaps your lordships would just read paragraph 10. And then the detailed reasoning follows in paragraph 63 to 69. And I've so 63. The UK says that Neura is consistent with the previous case law. Then they refer to.
It's quite carefully phrased, isn't it? A potentially valid interpretation.
I mean, what are you supposed to do? You've got a decision from the Court of Justice saying something, and what you're trying to do is try and make sure it doesn't go any further.
Well, the UK could have said Neura's wrong as well, but it didn't. It sought to justify that Neura was not inconsistent with any of the previous case law, but it said Neura is the limit, and to the extent that those submissions coincide with the submissions that I'm making today, I do rely on them, and I say the Court of Justice relied on them.
It wasn't necessary for the purposes of that case to say that Neura was wrong.
It may not have been, but the surprising thing we have today is that the controller is today saying that Neura is wrong, when it was apparently content to say that it was okay in 2017, and there's no, what's missing is any reason for the change of heart. There's no policy explanation or justification for the controller taking a different view today than it did in 2017. So, explanatory memorandum referred to in paragraph.
What do you say about paragraph 68? Because there, the position is that there's an inconsistency between Neura and
Yes, the way I understand paragraph 68 is that they are saying that on the facts of Yissam, an SPC should have been granted, but it wasn't argued the right way, because it was argued in relation to Article 1B, and as they point out, the last sentence of 68, that this court in Yissam was not invited to consider whether use could alternatively be implied into Article 3D. So we say that they are entirely consistent, with great respect, or I'm entirely consistent with the UK, perhaps that's the better way of putting it, and also in relation to the observations in 66 and 67. And the other point, of course, is that the United Kingdom court, this court, had said in Neura that SPC should be allowable. So if we talk about precedent, the last binding precedent of this court
This
is
is jolly interesting, and obviously it supports your argument. But how is it relevant as an aid to interpretation of the regulation?
I rely
Admissible as an aid to interpretation of the regulation.
Well, I rely on it for three reasons. Firstly, we say it's consistent with our argument. Secondly, we say that the difference between Abraxis and Santen is that the Court of Justice did not have the benefit of these submissions in front of it in Santen. And we say if it had had the benefit of these submissions in Santen, it may well have come to a different consideration.
Well, how do we know that?
Well,
how do we know that other parties didn't put exactly the same arguments before the court in Santen?
I'm going to come to Santen next, and I'm going to show you why Santen we say is clearly wrong. And so, had the court had the benefit of these submissions, we say it might well have come to a different decision. And then the third point, as I say, is that no explanation has been given as to why apparently this exception was sensible and permissible in 2017, but it is no longer permissible for policy reasons today, and that we say is a hole in my learned friend's position. So finally we get to Santen. This is tab 15 is the Advocate General's opinion. And can I just direct your lordships to paragraph 10 of the Advocate General, where the facts were set out. And the point I'm trying to make here, maybe the detail is unnecessary, but it was a much more difficult case, the Santen case. In particular, the patent relied on was mostly a formulation patent, but then had some uses tagged on in claims 23 and 24. In fact, the use that, one of the uses that is cited in claim 24 is uveitis, which is the use that the original MA had been granted for. So there was crossover between the use in the subsequent MA, in the subsequent patent and the original MA. Now, it may be that is not dealt with by the court, but I'm just pointing out that the facts were very much more complicated and less clear in that case. Is it really a second medical use case at all? And even if it is a second medical use case, it does seem that the claims of the patent cover the first medical use, and that makes it potentially different to the case before your lordships and indeed to Neura. The Advocate General, if I pick it up at paragraph 20, where the Advocate General acknowledges that Neura is reliant on a teleological interpretation of the regulation. 21, they go on to say, the Advocate General says, needs to be clarified. And then 22, they say, the Advocate General says it's not consistent with the product case law and can't be seen as an exception, that is Neurim. But as we've seen, the UK government in Abraxis has said it was, could be seen as an exception, it was consistent, and apparently the Advocate General either wasn't aware of those arguments or was unwilling to accept them, even if the Advocate General had been aware. But we say this is a difference between Abraxis and Santen, and indeed Neurim, and the arguments simply don't appear to have been made in the same way in Abraxis, which may well in Santen, which may well explain the outcome. So when we get on to paragraph 30,
En passant, we note he refers to the Max Planck study at paragraph 23, and nobody's favoured us with that.
No, indeed, my lord. So paragraph 30, is where the Advocate General comes to his conclusion. He says there that the Neurim judgment effectively circumvented the earlier case law. And for the reasons I've given, we say that's wrong. The Neurim judgment was not contradictory or inconsistent with the previous case law, as the UK government had argued successfully in Abraxis. And therefore we say that the Advocate General fell into error, and indeed the court fell into error in the reasoning which it adopted in coming to the decision it did. And the same goes for 38, where the Advocate General suggested there was a contradiction between Neura and the earlier case law. Then we get to 49 to 51, where the Advocate General says that not all pharmaceutical research should be protected. And it may be that not all pharmaceutical research should be protected, but that doesn't necessarily exclude pharmaceutical research leading to valuable second medical use inventions, as in Neura. And so when the Advocate General notes in paragraph 51 that paragraph 25 of Neura and paragraph 37 of Abraxis are contradictory, again, we respectfully suggest he was wrong. He didn't have in mind the explanation that the UK government had given in the Abraxis case, and whereas in Abraxis the court was treading a line which allowed for the validity of Neura, accepted that Neura was not contradictory of the previous case law, but where in Abraxis they decided to draw a line preventing formulation patents from being rewarded by SPCs. And then finally, in the reasoning of the AG, we have paragraphs 58 to 60.
Can I just pause a minute at 52?
Yes.
Where the AG rather downplays the explanatory memorandum
Yes.
and comes back to that at 54.
Yes.
So he's saying really that you've got to look at the regulation. You can't just base yourself on the explanatory memorandum.
Yes, and the court goes further and just says it's a literal approach. And we say that's not construction. That's just deciding or justifying an answer by the words of the regulation, and not actually performing the proper construction process.
Yeah. Right. Now you wanted us to go to 68.
58 to 60. So 58, they seem to say that the pharmaceutical industry had changed. They say, 58, second sentence, that interpretation undoubtedly lends flexibility to the SPC system and responds more fully to the current needs of pharmaceutical research, which seem to be different from those which led to the adoption of the regulation. We suggest that's not right because of the express acknowledgement of new uses of old products in the explanatory memorandum. But even if it was right, we say under the proper principles of construction, that's something you're allowed to take into account in attempting to give effect to the statute. But otherwise, they do acknowledge the importance of second medical use inventions in that passage. Then in 59, they say, the Advocate General says no support in the explanatory memorandum. We say that's wrong. And they say, the last sentence of 59, they say the schematic incoherence described, created by case law, must therefore be resolved by case law itself. This case gives the court an opportunity to do so. And with the greatest respect, that's not the construction, that's rewriting the statute. And if the case law previously had adopted the proper approach to interpreting the legislation, you can't change your mind and have a case which resolves it in a different way without properly justifying the purpose and where the construction fell into error previously, and the court, neither the Advocate General nor the court did that in the Santen case.
Yeah, it doesn't detract from the point you just made, but of course, as he notes in paragraph 61, in the result, he agrees with the Advocate General in Abraxis.
Yes, of course. As I noted, the Advocate General of Abraxis was not a fan of Neura, but the court
He had benefit of the UK submissions.
Yes, but in the end, it's the court that matters, not the Advocate General, and the court ruled differently. And so in 60, it seemed to be of most importance to the Advocate General was the unifying role of the court. And of course, in referring to that, the Advocate General was referring to the desire to try and unify the law across Europe and make sure that each state is applying a similar approach. That is no longer a concern that this court needs to have. This court is only determining the law of the United Kingdom, and so there is not the same concern about unification as runs through some of the European case law.
I think, strictly speaking, we're only deciding the law of England and Wales.
Indeed. Well, that is probably correct, my lord. I'm not sure there have been any SPC cases in Scotland or Northern Ireland in the history of the regulation, but I suppose it's possible that they could arise. And so the final part of 60 is where the Advocate General says, that is why favouring a teleological reading of the regulation, which, while having the advantage of protecting and encouraging other forms of pharmaceutical research, departs from the clear wording of its provisions, which reflects the balance between the different interests at stake, etc. So what the Advocate General is saying there is, you should not be adopting a teleological approach. Instead, you should be adopting an approach which focuses only on the clear wording. And we say that is the wrong approach to interpreting legislation. He has just sought to ignore the purpose, say the purpose isn't relevant. All you need to do is to follow the clear wording, and then in 61 he refers to the literal interpretation.
Fair summary? I mean, isn't the point he's making, I mean, he doesn't say it out loud, but the point is, as I read the point he's making, putting it in stark terms, across the territory for which this law is meant to apply, there will be some states in which their economies are favored by second-use patenting and extending those monopolies. Other states which may have a well-developed generic industry, who might rather those SPCs weren't granted. And so to take a teleological approach which involves encouraging some kinds of pharmaceutical research over others is stepping into that balance across the territory in which this is applying. And that's why he says you should go to the wording and not start doing judge-made law.
We would respectfully suggest that the balance has been set by the legislation, purposefully construed. But what the Advocate General is trying to do here is to say, no, I'm not going to purposefully construe it. I'm going to construe it literally. And we say that's just the wrong approach. It depends what you think the
purpose is, doesn't it?
Well, it may be.
And one of the purposes, no doubt, is to encourage pharmaceutical research.
Yes.
Without question. Another purpose is that people shouldn't pay too much for prescription drugs.
Yes.
So they're both purposes, and that's why the Advocate General talks about delicate economic and social policy choices. They're both within the purpose of this regulation. And if you say, oh, well, the purpose is simply to encourage pharmaceutical research, you're distorting the overall purpose. You're focusing on one purpose, which has to be balanced against other purposes.
Yes, I accept that, but he seems to be abandoning any purposive reading in that last sentence of 60, and we say that's the wrong approach.
Well, I'm not sure that is what he's saying. He's saying favouring a teleological reading of the regulation, which has the advantage of protecting and encouraging forms of pharmaceutical research. He's saying you shouldn't be making that the only purpose of this regulation. It's not. There's a balance. And the balance is struck, as you rightly say, by the legislation. And the only way to find that balance is to look at the words.
Including the explanatory memorandum. And we say that's where we do get support, which may not have been present or may not be as apparent for a formulation patent. So, my lords, that's the Advocate General, and then the court follows the next tab, as my Lord Arnold pointed out, it is the Grand Chamber. If we pick it up at paragraph 39, 43, firstly, that's where they deal with product, and that is consistent with the wording that and the understanding that we submit is correct. So it's a narrow. Got no problem with that.
So I think the real key part of this, I would suggest, is paragraph 34. The questions are based on the premise arising from URIM. It's possible for to get an SPC for a new therapeutic application of an active ingredient.
Yes.
And para 60, it says the premise on which the referring clause relies, mentioned in paragraph 34, must be disregarded.
Yes.
And that's as
That-
clear
that-
as
that-
it
that's
can
the-
be that they're
yes.
saying that URIM was wrong.
Yes, and I accept they are clearly saying that Neuram's wrong. I don't shy away from that. But we say the reasoning is impoverished, and that's why we say
Say 53 in terms that Neura is wrong.
yes, yes. But we say you shouldn't follow Santen. You should prefer Neurim and the Court of Appeal in Neurim. And the reason is that the reasoning starts to go off the rails in paragraph 44. So paragraph 44, they refer to Article 4 of the regulation, but then at the back end of paragraph 44, they say, and that the intended use of the medicinal product does not constitute a decisive factor for the grant of an SPC, and they refer to pharmacia. But that second part doesn't follow from the first, and of course, as we've seen in Forsgren, the use may be a relevant factor in deciding whether or not an SPC should be granted. So these general statements are simply not right. And of course, as we've already seen, pharmacia was not a case that was concerned with Articles 3B and 3D. So again, applying general statements made in an earlier case to the specific facts of an argument in this case, we say it is not fair. Then in 48, they have what is a correct description of the point, but then in 50 and 51, they revert to the literal wording of Article 3D, and we say that is again a mistake of construction. They are not considering the purpose, they are only considering the wording in accordance with the suggestion of the Advocate General, and we say that's not construction, that's just impoverished and incorrect reasoning. 51 appears to be, with our greatest respect, circular, because in 51 they refer back to Abraxis, paragraph 34, and if you just flick back to tab 14, paragraph 34 of Abraxis, in that paragraph they were only referring to the literal interpretation of Article 3D. They weren't considering, the court wasn't considering the purposive or teleological interpretation. And so we say that again, they have fallen into error by failing to consider the purpose of the SPC regulation. Equally, in paragraph 52, we say it's circular because they are simply referring to the wording of 3D and not considering the overall purpose and objective of the regulation, contrary to the way in which the Court of Justice itself has set out that this legislation should be construed. And then in 53, we have the words, it follows that, and really that just states a conclusion rather than, a bit like the Mediva case, it doesn't justify the conclusion other than by saying we're only going to look at the literal wording and no further.
Well, is that fair? Because at 54, certainly to 58, they do consider the objectives.
Yes, they go on to, but they should be, they're doing it in two steps, and really they've made their decision in our submission at the first step based on the literal wording, and so they don't pay much lip service to the objectives, and even if they do,
see decisions of domestic courts interpreting legislation, where first the court considers the literal wording, and then asks itself whether the purposes of the legislation leads to a different conclusion. That's a very common approach. You can see it in many decisions of the Supreme Court.
It's what we now call an iterative approach.
Well, so be it, my lord. I'm trying to persuade you of the reasoning in Neurim should be
Yeah.
preferred. And so we can look at the reasoning in 55 to 59, and we say it is incomplete, although they say not all pharmaceutical research should be protected. They don't seek to draw a line between second medical uses and other types of pharmaceutical research in the way we say that Neurim and indeed Abraxis has carefully done. They suggest that there's a fair balance in 57, but we say no for all the reasons given by Lord Justice Jacob in Neurim, and indeed the Court of Justice in Neurim. And we say that the suggestion in the end of 58 that the explanatory memorandum is only to be interpreted as referring to a second medical use where the first, where the product had never previously had an MA, is impermissibly reading wording into this explanatory memorandum, which isn't there, because of course the explanatory memorandum is talking about products, as I pointed out to you, and products, as it defines the previous page, are active ingredients that have been granted an MA. So to suggest that the explanatory memorandum, when it refers to products, isn't really meaning product, it's meaning some sort of substance which has not been approved, we say is an unfair interpretation of both the literal wording of the explanatory memorandum and its purpose. So, my lords, we say, for all these reasons, that the reasoning in Santen is not convincing. They haven't done a proper job of construing the legislation purposefully. And that for that reason, we say that the reasoning in Neurim is to be preferred. We also say that the Santen judgment doesn't consider that Neurim is in fact consistent with both MIT, Pharmacia, and indeed YISM. And we say that's a further error that the court fell into. If it had had the benefit of the UK submissions, it might well have come to a different conclusion, or at least it should have considered whether Neurim was inconsistent. And we say even the inconsistency in paragraph 44 with what's said in Forsgren is apparent, and it shows that the court hasn't properly thought all this through. So, my lords, overall we say, in the words of the practice direction, it would be right to depart from Santen because the reasoning of Santen leads to a result which is unjust. I'm not merely trying to suggest that a different tribunal would have decided it differently. We go further than that. We say that Santen was wrong for the reasons we've given. We suggest that there are no countervailing public policy arguments which apply. There's no suggestion that if your lordships were to re-adopt Neurim, that would retrospectively disturb contracts or fiscal arrangements, etc., as referred to in the Supreme Court practice direction. And indeed, the law was, as contemplated in Neurim, between July 2012 and July 2020, only 5 months before IP completion day. And we say reverting to that law within a few years is not going to cause industry or the general public any problem or inconsistency. If anything, we say it's Santen which has caused the discontinuity and uncertainty, not the present case. It's Santen which undermines legal certainty in a significant way, not Neurim. And we point out overall that I think I went on the IPO website yesterday, there are just 50 SPC decisions reported on the IPO website since 2000. So you are not seeking to, and only a very small proportion of those would be concerned with second medical uses. So this is not a floodgates point or a point where your lordships should be concerned. There's going to be a plethora of cases. And of course, when thinking about whether you need to balance the various systems in play. You also need to have regard to the fact that in the pharmaceutical industry, there is a rebate system, and pharmaceutical companies that make profits have to pay those back to the government. So even allowing pharmaceuticals to be protected for a longer period doesn't necessarily mean it's going to cost the public purse anymore. So there is an overall balance to the system which is already taken account of within the patent and SPC world.
Doesn't that depend on where the company in question pays its tax?
Well, it may. Well, I'm not sure it does. Any pharmaceutical that's sold or in the UK will be part of some sort of mechanism for regulating the profits that are being made, and so it.
We construe the SPC regulation by reference to the PPRS.
I'm not asking you to construe it, my lord. I'm just saying that there is no public policy argument that says, oh, you should never give protection to additional protection to products because that's going to cost the public money, because it may not even cost money, but of course there is the additional benefit that you're encouraging research, and that all has to be weighed up, and it is a complex system which we say does balance all these particular interests already. Penultimate point is I was asked to look at address Neuron, tab 19, and whether anything in Neuron could be said to be binding on the court in this case. And we say no, and we say the reasons for this are several. The Neuron was an Article 3B case, not an Article 3D case. And although the two are connected, for the reasons we've discussed, the ratio of Neuron doesn't affect the findings in this case. In any event, that case turned on its particular facts. It turned on the disclosure of the SMPC, and your lordships will recall the question was there was an active sulfonamide. It was combined with levodopa or PDI to treat Parkinson's. In fact, levodopa and PDI being well known to treat Parkinson's. And the question is, what was the product in the MA? Was it sulfonamide alone, or was it sulfonamide plus levodopa and PDI? And your lordships held that it was only sulfonamide, because although there was some reference to it being used in conjunction with levodopa and PDI in the therapeutic indication section of the SMPC, it wasn't the product, it wasn't the active ingredient designated overall, and therefore on the facts you held that the product was only sulfonamide, and therefore an SPC wasn't allowable. It's right that you did review some of the case law that we've looked at today, and indeed your lordship, Lord Justice Birss, quoted from in paragraph 21 from what you called Lord Justice Jacobs' persuasive judgment in Neura. You then refer to, you say, what might be called orthodoxy was restored in Santen in paragraph 22. But in doing so, you were only commenting on the meaning of product. And we say, as we've submitted, that's not inconsistent with Neura or the submissions that I'm making to your lordships today. Because in that case, the applicant or the appellant was seeking to leverage the reasoning of Mediva and not Neura. And so any wider comments which your lordships made in coming to your decision are strictly obiter. And I venture to suggest it could also be said to be per incuriam, if I'm wrong about that, for the reasons I've been over, because in contrast to this case, where we made clear to the examiner from the outset that we would be seeking to argue that this court should depart from Santen with its newfound powers, it was never argued before your lordships in Neuron that you should exercise your powers to depart from CJU case law under the Withdrawal Act.
Can't be the test, can it? I mean, you're right, it wasn't argued. One can see that. And of course, if you're right on your previous points, none of this matters. But let's assume you're wrong on all the previous points. The mere fact that no invitation to depart was made in Neuron can't affect its binding status on this court, can it?
Well, if you weren't invited to think about whether or not you should be following the Court of Justice, case law, then we say that when today I'm asking you to decide whether you should be following Santen, that's a completely different point, which your lordships weren't asked to turn your minds to in Neuron. And so it would be per incuriam to say, well, we didn't think about it in Neuron, we followed the Court of Justice, and now we're being asked not to follow it.
Just a minute. If we thought that Santen was correct, we would not depart from it. We have to be persuaded first that Santen is incorrect before the question of departing from it arises. In Neuron, we were given the choice. Is the law as in Neurim, or is it as in Santen? And what my lord said very clearly, paragraph 30, is it's the laws in Santen. So we have decided that as between Neurim and Santen, Santen is right and Neurim is wrong. That's what the whole decision is about. We have therefore applied post-transition, whatever the phrase is, EU case law. And unless you can persuade us that you're within a Young and Bristol aeroplanes exception, as I see it, we're bound by it. And the fact that an argument has not been put to the court is not a Young and Bristol aeroplane exception.
But with respect, my lord, the reason you were asked to decide between Neurim and Santen was because neither addressed expressly the point that you were dealing with in that case. Because if you'd plainly, Santen says it's overruling Neurim on the narrow point that's now before your lordships, and so your lordship, my Lord Justice Birss wouldn't have had to write any of that of the previous paragraphs if it had only been a case of deciding whether Santen overruled Neurim. So that wasn't the point before your lordships in that case. You were deciding a different point under Article 3B, and it may be that you prefer Santen on Article 3B to Neurim, but that doesn't determine the outcome of this case, which is
paragraph 30 expressly, having listened to your argument this morning, it seems to bear exactly on the argument you're putting to us, which is what is the correct approach to the SPC regulation? Is it the teleological approach of Neurim or the literal approach of Santen? And in this court, as it happens, it was me, but it doesn't matter, decided against you. The approach to the interpretation of the SPC regulation is the literal one of Santen, in your words, rather than the teleological one of Neurim. That's exactly what paragraph 30 decides.
well, my lord,
So we followed Santen, and under the statutory instrument that applies to this court, Santen has been applied by the Court of Appeal to the question you're asking us to answer, which is how do you interpret the SPC regulation? That's it, isn't it?
well, you were being asked this completely different question about whether or not what is the definition of product.
Yes, but part of what we were being asked about was, do you apply a teleological approach or a strict approach, if you will? And Santen decides Santen is one way, and Neurim is the other, and that's been addressed in para 30. Exciting.
The difficulty is I don't have any problems with the outcome of Neuron in terms of the definition of product and looking and the interpretation you arrived at of the SMPC.
Sorry, the only cross purposes, Mr. Bishop, the issue is whether this court can depart from a decision of the Court of Justice, which this court has applied.
Yes.
Which is what the statutory instrument deals with. At least on the face of it, speaking for myself, this court has applied Santen, as it happens, more than that, not just in some sort of random, irrelevant decision, but on precisely the question, as far as I can see, the overarching interpretation question you're asking us to decide. We've applied it. So, in order to work out which court has the authority to depart from the EU, this court, having already followed Santen and applied it, it's not this court, it's somewhere else.
Well, perhaps I should have addressed this first and saved everyone a lot of time.
Can I just ask the same question a slightly different way? Because the issue for the purpose of the regulation is not whether we are bound by Neuron as a matter of domestic precedents, because if we were, you couldn't argue the matter anyway, purely on domestic law. So the test you were positing of saying, well, what's the ratio of neuron and does it apply in this case, can't be the right test, because if it were the right test, you'd have to go to the Supreme Court anyway. So what the regulation is doing is something slightly different. It says, so far that as there is post-transition case law which modifies or applies that retained EU case law, and which is binding on the relevant court. So here we have a binding decision, Neuron. You can't dispute its binding for what it decides, because it's coordinate jurisdiction. We are bound by ourselves. No young of Bristol applies. And then the question is, did this court apply that post-transition? Yes, it did. Apply the Court of Justice case law in that decision.
Yes, it applied it to the interpretation of Article 3B. And that's where I say there's a difference in position, because had it applied it to the interpretation of Article 3D, then I may well be in a different position, but it didn't. The court was asking itself questions under Article 3B, and at a high level, of course, I accept paragraph 30. You preferred the approach of Santen, but you weren't asking yourselves the question that's before your lordships today.
But that's coming back to the point I was putting to you, and I'd be grateful if you could just focus on the test under the regulations. So let's take it in stages. Do you accept that it cannot be the same test as the ordinary domestic test of precedent? Because otherwise it would be completely redundant.
When you say the regulation model, you mean the
It's Regulation 4 of the European Withdrawal Act 2018 relevant court retained EU case law regulations, which is the regulation I think that we drew to your attention in advance of the hearing.
Yes, my lords. Yes, so I was not approaching this on a different basis to the law of precedent.
But if your submission is that the test is exactly the same as under the domestic law of precedent, then this regulation is completely redundant and does nothing.
Well, that's not right insofar as it is expressly setting out the circumstances in which your lordships can depart from EU law, which is a different point. I accept there may be an overlap, but to that extent, this regulation, the purpose of this regulation is to explain that there are circumstances in which not only the Supreme Court but also the Court of Appeal may depart from EU law.
Well, the position, as I understand it in summary, is that we can depart from EU law in circumstances where the Supreme Court could depart from one of its own decisions, unless there is post-transition case law in this court which applies that EU law. In which case, unless you're within Young and Bristol aeroplanes, we're bound by our previous decision.
Yes, and my submissions on that are that Neuron didn't decide the point that you're now
you say it's obiter, so therefore we're not bound by it.
Yes, and nor was it suggested to you in that because of the way the arguments were put, it wasn't suggested to you that you could prefer Neurim to Santen on this point. And we've been over the fact that plainly Santen expressly said it was overruling Neurim on Article 3D.
But can I just come back to the wording of paragraph 2, which modifies or applies? So if there's modification, then it's inherent that you can't possibly have stare decisis. So I'm at a loss as to how you construe paragraph 4.2, because the effect of your submission seems to be constantly, it's the same test as in domestic law. If it's not part of the ratio, then we can forget about it. But that can't be right when it says modifies or applies.
You want to answer my Lord's question at 2 o'clock?
I will do that. I attempt to do that.
2 o'clock.